This is navigable water. That's what the government calls waterways like rivers and lakes. The EPA is supposed to keep this water from being polluted. This is residential land in an Idaho subdivision. It's owned by Mike and Chantel Sackett. For 15 years, the EPA said Mike and Chantel can't build a house here without first obtaining a federal Clean Water Act permit, which costs hundreds of thousands of dollars. The EPA says this land contains wetlands that have a significant nexus to a waterway. What does that mean? Hold on to your hats. There are wetlands here to the north of the Sackett's property, but look, you've got to cross a 30-foot paved road and a ditch to get there. And there is navigable water down here to the south of the Sackett's property, but you have to cross a different road and cut through a row of houses to get here. So why does the EPA think building a house on this property would pollute the waterway? This is the nutty part. They say this ditch up here, across the road, spills into a non-navigable creek a few thousand feet west of the Sackett's property, which then flows into the lake all the way down here. So to recap, the EPA is going to the Supreme Court to block housing on this residential lot because they say across the road there are wetlands next to a ditch, and a few thousand feet over, the ditch runs into a non-navigable creek. And then down here on the other side of another road and a bunch of houses, that creek empties into Priest Lake. This is the EPA's brazen expansion of what counts as navigable waters. If you think the EPA cannot claim more power than Congress gave it, follow what happens with the Sackett case at the Supreme Court.